Okay, so good morning and welcome to the second day of this fantastic conference, interdisciplinary conference on Jewish rights, minority rights, and human rights. I'm Rachamimov. I come from the Department of History here at Tel Aviv University, but I'm also representing the Israeli Inter-University Academic Partnership in Russia and Eastern European Studies, okay? Yeah, I think I got it right, which is a consortium of five research universities in Israel, and we are trying to further academic research, excellent research in Russia, on Russia and Eastern Europe, whether historical or from other perspectives. We'll be focusing this morning on Eastern Europe, either the Soviet Union or, in the Israeli case, the Middle Eastern Europe. As we heard yesterday, a lot of some of the genealogy of the Israeli discourse on rights, Jewish rights, human rights, minority rights, originated in Eastern Europe. And some of the practices we heard from Marcos and other people had actually, been framed, thought out in context of certain nationalist discourse and nationalist practices in Eastern Europe. So actually, the connection is not that far-fetched, even though I'm not sure all papers will deal with socialist societies. Two of them, at least, will be dealing. Our first speaker today is Dina Moyal. Dina Moyal holds an LLB degree from Tel Aviv University and a PhD degree in history from Stanford University. She teaches here courses on Soviet history and the history of Soviet legal system, and her research includes studies on Soviet post-Stalinist history and relations between the political and the legal spheres in totalitarian regimes. And the title of her paper today is Between Human Rights and Citizen Rights, the Soviet Legal System under Stalin's Successors. And I was asked to give you this trophy.
Thank you. Okay. Thank you very much, everyone, for coming. Good morning. So indeed, this panel moves us forward in time towards the period of the Cold War and the struggles of Jews in the Soviet Union and Israel for rights. And in this paper, I wish to set the ground for this discussion by examining the existence of the discourse of rights in general in the Soviet Union, and then specifically in the period of Stalin's successors, Khrushchev and Brezhnev. But any discussion of human rights in a Soviet or socialist context, I think, is a classic misunderstanding, I can call it, between Western liberal concepts and Soviet ones about rights. The difficulty to find meaningful references to human rights in the Soviet world is often interpreted as the general absence of any rights and liberties in Soviet polity. It is particularly easy to reach this conclusion in view of our knowledge of Stalin's terror of the 30s, Gulag administration, which continued to function after his death, Soviet disrespect for human rights during and after World War II, late Stalinist purges, and then in the post-Stalinist era, we'll hear about the dissent movement and so on. And the general concept is that if these groups did not get to exercise their universal human freedoms as we treat them, then freedoms such as movement, freedom of speech, freedom to demonstrate, due process of law, etc., then actually there is no point in searching for any other rights in the Soviet Union. In a way, if I may, it echoes Professor Moyal's lectures of yesterday. If we don't have a floor, can we look for the ceiling? Can we build anything if we don't have our basic human rights? But if we follow this common approach to Soviet reality, then I think our discussion and understanding of Soviet society is bound to reach a dead end quite fast, and it will leave us with a quite simplistic conclusion of they either, Soviet regime gave human rights or did not give human rights, and it was either good or bad, and we won, and that's it. So I propose here to broaden our discussion of the subject in 4 directions. So the first is by asking the question whether Soviet citizens had any kind of rights. Human, other, how can we call them? And if so, what would be the best way to characterize them? The second is by looking at the way ordinary Soviet people experienced rights in their day-to-day lives, moving away from political activities and dissent. The third thing is actually taking into account that the process of defining rights, even in polities as the Soviet Union, is actually a two-way process, going both top-down but also bottom-up, as citizens themselves develop, help define their rights and defend them. And in terms of periodization, I will examine the question of human rights. I will focus not on Stalin, but on his successors, when the discourse of human rights actually became part of the Cold War rhetoric. And I think this will help us understand the discourse of human rights in the Soviet Union. And yet, I think in order to move into that period, we have to start a bit earlier and still have a really little introduction about Marxist approaches to human rights and early Soviet ideas. So we should start this talk with reminding ourselves that although the question of human freedom was a central philosophic issue for Marx, the term human rights was missing from his writing. Marx severely criticized classical liberal conceptions of freedom, which he thought had a heavy class content in them. And so he rejected common legal political conceptions and safeguards of freedom. And the concept of human rights was exactly one of them. So as Andrei Velitsky beautifully puts it in his Marxism and the Leap to the Kingdom of Freedom, he says, freedom was conceived by him, by Marx, not as an absence of external coercion or constraint, but as the ability to live in accordance with man's essential nature, that is, as the opposite of dehumanization. And he further explains, he, Marx, did not concentrate on the problem of governmental intervention in private life because, in his view, the very existence of a private sphere in which individuals were allowed to pursue their particular egoistic aims was a symptom of dehumanization, a symbol of unfreedom. So in this sense, the very starting point of communism is so different from our own Western liberal concepts. Yet Marx does insist on freedom and humaneness, at least in his writings. So the communist and Soviet vocabulary discusses humanity, humaneness, freedom, but not human rights as a political and legal term designed to protect the individual. Moreover, the libertarian approach, or attempt to defend personal freedoms and let the free market rule, free market both in the economic sense, in the sense of ideas or desires, is an extreme case of unfreedom, according to Marx. So true individual freedoms exists only in a communal freedom. And Marx compared his generation, actually, to the Jews whom Moses led through the wilderness out of Egypt, and we're approaching Passover. So this generation must perish in order to make room for people who will live in a true equal world. So hence, our attempt to look for human rights in their traditional liberal meaning in Soviet society is bound to fail. And we need to because real freedom will exist only in true classless communist society. In this society, we would no longer need state mechanisms to manage people and law as a state tool and as a reflection of power relations in society would wither away together with the state. And terms such as human rights would not be needed at all. The question of realizing this new regime, however, was much more complicated, as the Bolsheviks found out quite early on. And they realized, right in the start of the revolution, the difficulty of establishing a new order without state mechanisms or law. In his State and Revolution, written in 1917, Lenin insisted that law could not be completely disposed of from the start and claimed that it was still needed in the transition period from capitalism to communism. Moreover, while the Bolsheviks could easily ignore law and rights in times of emergency, it was much harder to do so once the Civil War was over. Hence, after the initial abolition in 1917 of Tsarist institutions, by the early 1920s, the new regime reestablished state ministries in the form of people's commissariats and legal institutions such as a three-tiered court system, the procuracy and advocacy. In the early 1920s, that is before Stalin became the head of the Communist Party and debate about the right way to communism was still possible, Soviet legal experts actually acknowledged the difficulty of granting individual rights in the midst of revolution. So in an article in Izvestia of May 1921, the head of the Supreme Revolutionary Tribunal, Nikolai Vasilievich Krylenko, wrote, "There are topics that cannot be touched without punishment. To these topics belongs revolutionary legality. The ability to establish a revolutionary period strictly specific and the ability to establish in a revolutionary period strictly specific and unbreakable norms according to which repression as a way of struggle and the state's self-defense would strike the heads of only the enemies of the social order, with minimum mistakes and maximum guarantee of the rights of the individual. The essence of the contradiction in this situation is the conflict between the needs of the day, which are constantly changing and flowing, and the natural entitlement of the individual to the mentioned series of secured rights." So as far as rights were concerned, there was no talk of human rights, but a discussion of rights of the individual, rights of Soviet citizens, since only those who lived under the new system could benefit from this new kind of rights regime. In practice, of course, the true rights the new regime guaranteed for citizens could be enjoyed only by those who were not class enemies. In the early Soviet period, a whole strata of people, clerics, nobles, former state officials, officers of the White Army, were denied basic rights given for free to other Soviet workers. So the right to vote, the right to a workplace, the right to housing, free education, and free medical assistance were in this or that degree taken from these groups. Lenin's 1918 Constitution of the Russian Republic defined these rights, but excluded certain groups from their exercise. But as the Lenin Constitution did not identify clearly enough these categories of bourgeois aliens, Soviet citizens were negotiating their status and identity with the authorities in order to restore their rights, and actually historians tell fascinating stories about this process. One of the works is by Golfo Alexopoulos, who tells in detail the story of Soviet outcasts, the Lishemtse, who experienced this politics of deprivation and reinstatement of rights as a way of the formation of Soviet society. So this is, in a way, of introduction to how the Soviet Union treated, and I'm not I wish to move forward and then leave other subjects for questions maybe, and move forward to the discussion of rights after Stalin. So the question of citizen rights became a central one after Stalin's death in March of 1953. The hardships of World War II, experienced by all Soviet citizens, created a sentiment of entitlement and great expectations for renewed building after the war. Everyone fought for Soviet victory, and all deserved their rights as citizens. Some of these demands were no doubt intensified due to the exposure of many soldiers and citizens to Western European, Central European reality during the war and the demand for better life. This did not happen under Stalin, however. The purges of the post-war era, the famine in the Ukraine, and party rivalries left the population disappointed. Therefore, after Stalin's death, the new collective leadership, Khrushchev, Malenkov, Molotov, Beria, realized that the change of policy was needed in order to gain legitimacy, win popular support for party policy, and promise security to the people. Moreover, the party itself needed security and stability after several waves of purges conducted under Stalin within high party echelons, distressing the very system which was supposed to lead to socialist building. Less than a month after Stalin's death, the new leadership issued an amnesty, releasing 5 million prisoners from the camps. The amnesty included all men sentenced to 5 years or less for non-political crimes, and almost all women and children. According to the then Ministry of Justice, this was a sign of Soviet humaneness. And the official explanation was that these people no longer constituted a threat to Soviet socialist society. Soon thereafter, a banner of socialist legality was lifted, claiming that strict observance of the law by both state and the citizens was crucial for defending the rights of Soviet citizens. According to official Soviet publications, it was the absence of legality that caused the fabricated charges against the Kremlin doctors and the false accusations against other party members, but Beria and his people from the NKVD. Massive rehabilitation campaigns started under the new leadership, along with releases from the gulags. In his famous speech, secret speech, at the 20th Party Congress in February 1956, Khrushchev acknowledged that Stalin's cult of personality tempered the principles of legality, allowing terror in the party, cleansing in the Red Army, failures in leading World War II, and the supremacy of the secret police with Beria at the top. Khrushchev's conclusion was that the party had to revert back to the true Leninist way, and that the restoration of socialist legality was key to the continuous building of socialism in Russia. From that point on, defense of people's rights according to the law became guarantee for the entire regime. Khrushchev's secret speech became a watershed, opening the way for concerted criticism of Stalin's cult of personality and a simultaneous call for keeping the law and the rights of Soviet citizens. So articles in legal journals brought up questions that had not been discussed for years in the Soviet Union, such as personal freedoms and constitutional rights of citizens, the right of the accused to defense, etc. Titles such as Personal Freedom and the Guarantee of Constitutional Rights of Citizens in the USSR, or The Right of the Accused to Defense in Criminal Procedure, or Defending the Procedural Rights of Citizens in Soviet Criminal Process. These were just examples of the titles of articles of those times. Such articles emphasized the role of legal officials as servants of the people and guards of socialist legality. The most important basis for further strengthening the Soviet state was Soviet socialist law and the defense of rights of Soviet citizens as recorded in the USSR Constitution. An Izvestia article written by Kudravtsev, Deputy Minister of Justice, elaborated on the importance of law and legality for the Soviet state, but also listed the rights of Soviet citizens, such as the right to work, to rest, to receive education and medical care, as well as economic security in sickness or old age. Contrary to previous articles of this sort, which only stressed the need to defend the state, this article also obligated the Soviet state apparatus to serve the state and the people with belief and truth, always strictly following socialist legality, vigilantly keeping the rights of Soviet people of any encroachment. Thus, in the Soviet Union, there was a call for rights, but not Western liberal rights, which are meant to bolster individualism, but rights which would enable to create a new society of rights as well as duties, which would then bring true freedom to the people. In a sense, we're turning the house we spoke about on its head, claiming that it was the ceiling which served the people better, and we can then move to the floor, putting it upside down. So the Soviet legal system was recruited as a central player in this goal of protecting legality, a mission which required not a small number of adjustments to make sure that the courts, the procuracy, the advocacy followed this new line. The newly appointed General Procurator, Roman Rudenko, was aware of the problem. He wrote, "A clearly abnormal situation had arisen," Rudenko wrote, "where the state organ, which is called upon to exercise supervision over strict enforcement of the law, was itself operating without a legislative sanction to regulate the procedures, limitations, and competence of its activities." And to solve this problem, on May 24th, 1955, the Presidium of the Supreme Soviet of the USSR adopted a new law, the Law on Procuracy Supervision. The law officially made socialist legality one of the goals of the procuracy. Article 2 defined the purposes of this mission as strengthening socialist legality in the USSR and the defense against encroachment of the social and state order of the social and state order of the USSR, the socialist system of economy and socialist property, and second, defending against the encroachment of political, labor, housing, and other personal and property rights and interests of USSR citizens as defined through law and USSR constitutions. So documents from former Soviet legal institutions actually indicate that not only the procuracy but other legal institutions as well demanded that their rights be broadened in order to properly defend Soviet citizens' rights. At a meeting of the Moscow College of Advocates with the Deputy Minister of Justice, Volchkov, one of the advocates, Advocate Lansky, explained, "It seems to me that the first and main mission of advocates is to significantly improve our work of securing the holy and untouchable rights of citizens. However, if we have to defend the holy and untouchable rights of citizens, let us first of all discuss our own rights. We cannot protect the rights of Soviet citizens if we do not have a guarantee that our own rights will not be infringed." And what happens with the Soviet citizens, we might ask. I mean, this was behind closed doors. Doesn't influence them. So the discourse of rights actually did penetrate into society. The rights of Soviet law, the rights that Soviet law protected were not universal human rights, but rights of Soviet citizens, rights and duties which were part of the new socialist polity that the Soviet citizens helped build. And these rights were not negative rights, but positive rights. They did not guarantee freedom of the individual, but access to the social rights Soviet citizens had according to the law. These were not many, but they promised them certain security, at least that was the promise of the leadership, also according to Khrushchev's memoirs. So archival documents show that Soviet citizens were quite fast in adopting the new discourse of rights and turned to Soviet authorities and legal institutions with demands to restore their housing, working, or even contractual rights. One of the citizens wrote, With this complaint, I turn to you for the restoration of legality and defense of my citizens' rights guaranteed by the Soviet Constitution, which were encroached by the courts of Georgia, wrote Antonina Baghdadze in her complaint in 1964, insisting that her share of housing space should not be given to her stepson following his father's death. Antonina ended her letter with the words, "I believe in the humaneness of the Soviet government, which will not allow that I will be thrown to the street." In 1964, another citizen, Antonova, from the city of Baku, Azerbaijan, opened her letter to Chief Justice Gorkin with the following words. "It has been 8 years already since I first turned to the judicial institutions of Azerbaijan and the Supreme Court of the USSR, and we still cannot restore our rights. Illegally, under the order of a number of former officials who abused their positions, the Soviet court was pressured, and therefore our sacred rights were encroached. In negotiating their rights with the state and party organs, most of the citizens operated within the range of rights that the Soviet system provided. They were not asked, and they internalized, in a way, the Soviet discourse of socialist rights, of citizens' rights, and demanded the state to stick to these promises. In his letter to the newspaper Izvestia, citizen Vibora, for example, suggested different measures for obtaining additional and new housing spaces. Confiscation of housing from those who did not perform socially useful labor, or confiscation of surplus housing space, which is often leased by the people who live in the apartment, and detect cases where people have housing space in 2 different cities. This letter was transferred by Izvestia to the juridical committee responsible for legislation, and Sukhadrev, the deputy chair of the committee, wrote back in reply. One cannot deny a citizen the right to housing without sufficient legal basis. To check this, however, a legal procedure was established. While you, the author of the letter, correctly point out the need to observe the law, you are nevertheless suggesting a solution that deviates from the law and diminishes the legal guarantees of the citizens. Some of your suggestions, for example, on the confiscation of private buildings, totally diverge from the approved party and state practices on individual housing constructions. So we see that this discourse of right penetrated also to the legal system and to the people. And I'm concluding, as these and other examples suggest, in the post-Stalinist period, law and legal rights of Soviet citizens became a central part of Soviet socialist discourse. In this new talk, the positive rights of citizens became a promise of the regime to its people. It was this promise, so I claim, that set a high standard before the post-Stalinist leadership and challenged it as the economic situation of the Soviet Union deteriorated in the following years. For the majority of Soviet citizens, it were these rights, not Western human rights, that bothered the people and served as a check that the leadership couldn't cash. Thank you.
Thank you so much, Dina.